Ma'am, I think we can start, and we are having students joining in. So, yeah. Okay. So, very good afternoon, everyone. I warmly welcome you all to today's online seminar on basics of intellectual property and their importance for innovation and entrepreneurs. In today's theme, it is especially relevant to us in the field of fashion because, as designers, as creators, our ideas, sketches, and designs are our most valuable assets. Understanding intellectual property rights helps us understand how to protect our creative expressions, prevent imitations, and build a more stronger professional identity. Through this session, we aim to develop awareness on how IPR supports creativity, innovation, and entrepreneurship in the fashion industry. I would request Khushboo ma'am, who is the speaker for today. Ma'am, I'd like to just start by introducing you. It's my pleasure to introduce Dr. Khushboo Bhurat, who is the founder and IPR filing and consultation specialist and a specialized patent agent and an IPR Mitra under the SIPP scheme. Dr. Bhurat also serves as the president of the Uttarakhand Intellectual Property Council, WICCI, and is actively involved as a researcher and startup mentor, guiding innovators and entrepreneurs in protecting their creative work. We are delighted to have her with us today to share her insights on the importance of intellectual property rights. Ma'am, I would like to hand over the session to you now.
Thank you, Smita ma'am, for lovely introduction. Uh, Thank you, everyone, for having me in. I'm really very glad to be connecting with you and talking with you about protecting the intellectual property rights of fashion industry. There is a very less awareness that even intellectual property rights are associated with fashion industry and something like jewelry industries and designing industry. I'm glad you and your organization has thought of creating this awareness amongst your student, which is need of an hour, and it's exactly the right time they should get aware about it because now right now they are into a very creative phase of creating new designs and processes and innovations in this field of design and in this field of fashion, and it's definitely worth knowing that they should be protected. So, hello everyone. I'm Khushboo Bhurat, and I'm practicing intellectual property rights since almost a decade now, having been filed more than 500 IPs till now. And I'm glad to make you all aware about the intellectual property rights. Although today we will just be touching up upon what intellectual property rights are and how they are related to your field. So, if you all are ready, can I share my screen?
Yes, ma'am, please go ahead.
All right. Yeah, I hope my presentation is visible.
Yes, ma'am, it is.
Yeah. So yes, today we'll be discussing about what intellectual property rights are and how they are relevant in this fashion, textile, and jewelry industry. So start with it is, but obvious, very important to know what intellectual property rights are. So I hope you all have heard this word intellectual property, IPR, or patents many times. But if you do not know about what it is, let me just simplify it for you. And if you break this word intellectual property rights into three sections, these are the rights, and read it, um, in the opposite direction, right, starting with the rights, that it is the right, these are basically the rights that you get over a property which you have created as a as your intellectual labor, through your intellectual labor. So when you put your labor in, your hard work, your mind, your creativity into creating something new, it is your property. And if it is your property, your own property, you should get rights upon it. Which rights? Rights to use it, exploit it, And now what do I mean by exploiting it? That you should have the right to make every decision about it, whether you want to make money out of it, whether you want to sell it to somebody, whether you want anybody to use it with your permission. So whenever you create any new property, even in case of house or jewelry or gold or money, if you create as your property, you want to have rights upon it, right? So you want to have those rights that nobody else can use your property without your permission. And that is exactly how intellectual property rights also work. The only difference is these intellectual properties are not your stable properties, not your tangible properties, but these are actually the creations of your mind. These are actually the products of your creativity. But it is equally important as any tangible asset. uh, like in case of your house, you can sell it, you can buy it. Same way, you can buy intellectual property, you can sell intellectual property. If you have, like, if you have a patent and you do not want to create business out of it, you can sell it to somebody who is already into that business, and so on and so forth. You can even mortgage it. Just the way you can mortgage your any tangible properties, you can also mortgage your intangible property, that is your intellectual property. You can exchange it. In case you have one house and you need another one, and you can exchange at times, like in the exchange of money or in the exchange of same product, like the house. So you can exchange intellectual properties also, you can license them. Same way as we rent out our house for some time, for some duration, to a specific person, you can license out your intellectual properties, your patents, your designs also, for a specific duration to specific people. So it is exactly similar to any other form of property. The only difference is it is not a tangible property, that is that you can touch and feel. It is the intangible property that you have created through your intellect, through your mind, and you should have rights upon it. And to give you those rights, there are different provisions available by Indian patent system and rather worldwide systems. So there are different types of IPRs under which these rights are given to specific inventions. So these are specific ones which are related to your specific industry, fashion industry. There are even more IPRs to add to it also, like there are personality rights, there are plant variety protection rights, but those are not related to your industry. So we are just going to discuss these ones, that patents, copyrights, industrial designs, trademarks, geographical indications, and trade secrets. I'm sure if you have not heard these names, you must have definitely seen these symbols that are down here in the lower line. So if you have seen these symbols, you might have seen this symbol on the logos and on the business names, while you must have also seen this logo on some of the trade names, that is some of the logos. If you know the difference, very very nice, but if you don't know, let me tell you what is the difference. So TM is used when you have applied for a trademark registration but it is not registered yet. And when it is a registered trademark, it is replaced by this R in the circle, which indicates that the trademark is registered trademark. So many times people fool you by writing TM on their logo, saying it is a registered trademark, but that's not true. TM is used for unregistered trademark. C in the circle, you will see this on many of your books, novels. Even the good designers protect their designs with the copyright, so you will see that those designs are also copyright protected. SM is service mark. You will see some fashion industries using SM on their branding names to show that they are service industries. They provide services of designing, they provide services of stitching only, services of manufacturing only. They are not into product business but into service business. There are fashion trainers also which use this kind of symbol SM, which is again an unregistered mark indication. When it is registered, it is always written in this form, R in the circle. Then you might have seen this trade secret symbol also, or patented symbol also. So these are nothing but symbols associated with IPRs. And let me tell you, IPR is not a single right or not a single property, but it's a bunch of different rights. It's a bouquet of different rights. And these patents, copyright, industrial design, trademark, geographical indication, trade secrets are some of them. Okay. And again, they are not, interchangeably usable. So patents cannot be said as copyright, or copyrights cannot be said as patent. They all have completely different meaning, and they all have completely different purpose. They all protect completely different things about the same product. Okay. So you will understand that during the course of this instructions. So how to understand, what is the right protection? Is copyright right for you, or is patent right for your protection, or is trademark right for your protection? So what you can do is simply imagine your maybe innovation, or maybe your idea, maybe your creativity as one idea, and think about it, that what is it related to, what is it creating, what is the outcome of it? Is it an invention? Now, what do I mean by invention? Invention means something that was not present before, that you have created new. All right. Like, for the first time when umbrella would have been created, it is an invention, right? But now if you create a different design of umbrella, that's not an invention. That's a creative expression of, making an umbrella, or making some new design of already available invention, right? But when something was not available in the world and you created it for the first time, that's an invention. And inventions are protected by patents. Then if you are creating something creatively expressing form, like, it can be article, it can be your, poetry, your designs, your jewelry designs, your, textile designs, some designs on the textile also, and your creative apparel designs also. So they are creative expressions of your thought, and those creative expressions are protectable by copyrights. Then you cannot protect those, expressions in by patent. Patents are specifically given to inventions, while the creative expressions are protected by copyright. Then you can also have some eye appealing designs to already available things. Okay, right. Like, again, apparel designs. If you are giving a design to some article, I mean, if you just doodle something on a paper or on a textile, it can be the creative expression of your thought. But until and unless it is given to an article, like you make a dress out of that material, it cannot be protected by industrial design. But if you create a dress out of that material, that uh, textile, then it can be protected by industrial design also. And there are more factors to it. We'll discuss this. Then if you have created a something like your logo, tagline, jingle, or anything which you think can be used for your company goodwill, your product goodwill, your service goodwill, then that thing can be protected under trademark. So it can be the name of your company, it can be the logo of your company, it can be the color combination that you use for showing up your company, or it can be any just symbol, any jingle, anything which is related to your goodwill, even taglines. So anything which is related to your goodwill, your product goodwill, your industry goodwill, your company goodwill, then that is protected by trademark. Most of you must be thinking of creating your own fashion houses in the future. If you do so, don't forget to to trademark your names, your logos, and your creative way of expressing your identity in the market. Because once you become famous, it is very easy for others to take a benefit of it just by copy pasting it, right? But before anybody does that, get it protected through trademark, because that protects your goodwill in the market. All right. If you are creating something which is related to plants, there are new plant variety ads which are actually not relevant to you. So let's just move ahead. Okay, so let us discuss these one by one. What patents are? Patents are exclusive right granted only and only specifically for inventions. Now, again, I'll repeat, invention is something that did not exist before, that is newly created for the first time. It is a negative right, which means it gives you a right to prevent others from using your invention without your permission. So it's very simple. If somebody wants to use your invention, they have to take your permission, they have to pay you some royalty or some licensing amount or some lump sum amount, and in return of that, you can allow that person, that industry, to use your invention. And that's how it is called as negative right, because it is to prevent others from using your invention. And of course, it's an intangible property like all other intellectual property rights are. So if you just think about what can be the example of patent. Okay, so this is the basic, very simple thing which the fashion industry, I'm sure, cannot live without: a safety pin, right? Now, do you think this is patented invention? Do you think that it can be an innovation and invention for that matter? So I'll tell you the story behind this. The inventor or the creator of the safety pin in the time of Second World War was having a debt of $5 to his friend. He had lost his job, and without knowing what to do now, he was just sitting in his workshop and playing with some wires, and he created this kind of product which was pointed at one end, looked at the other, and having a hook at the other end where the end can fix in. And he felt like this can be used to keep two things together, and therefore he got it patented for, again, using some more dollars through his friend. So he might have invested hardly a few cents in creating this invention and a few dollars to get it patented. But imagine that he sold out this patent at the time of World War II to a company at the price of 2000 US dollars. Imagine the value he must have earned at the time of World War II. The value of 2000 US dollars was huge at that time. It is now also, but at the time of World War II, imagine a simple safety pin earned him 2000 US dollars. And even that, the most interesting part is the industry who purchased this invention from him, this patent from him, uh, got royalty for every safety pin that was sold for next 20 years worldwide. And imagine how many safety pins do we have in our house? At least 20, right? So imagine how much money that company would have made through this simple invention. So I just wanted to give this example to let you know that no invention is small, simple. It doesn't have to be a rocket science to get it patented. It just needs to be new and useful. If it is so, you should protect it, because that may be a huge breakthrough for you, earning a tremendous amount in money. So another example of patent is this non-woven fabric cleaning wet wipe. So this wet wipe is created to clean the fabric, just the way we use wet wipes to clean our face and skin. These wet wipes were created to clean the fabrics, and they also are a very hit product in these days, and have been used by I mean a lot of celebrities and fashion industry people. And this is again a very huge market these days. And uh, just to have a knowledge about it, that even such kind of products are patent protected. Then there are wearables with special features, like this Michael Jackson shoes, which he had created just by adding an extra sole, which helped him to, have a grip on the stage, because of which he used to do this anti gravity movement and not fall down, thanks to this simple invention he had created. But only because he got it patented well in time, nobody else but only he could do this movement, because he had patented it, so it was only his right. And now after that, it is his company's right. So still date, it is a protected invention, and nobody else can use it without their permission, or in simple language, without paying them enough royalties. So it doesn't really have to be rocket science, but something innovative thought process that can be patented, and that can earn you uh, lakhs of rupees. Then there's hangers, which are templates for folding and hanging items for clothing. uh, had been created in Switzerland by, again, some fashion experts, and they created this simple hanger which can be used for folding the clothes also, not only to hang it but also to fold it and then hang it. And this simple design has got it patented, and again is a huge success in market. So uh, not only these, there are other products also, like non-woven fabric with improved mechanical strength. If you have already seen some limitations in the available product in the market, maybe in the fabric, and if you are coming up with some solution to it, you can come up with some dyeing solution, you can come up with some strength related solution, you can come up with some thermo stability related solution. If you are coming up with those solutions, it's an invention, and that is very well protectable by patent, and it should be protected by patent. And you can sell it, you can license it to whoever is there in the industries, and earn a lot of money out of it. There are fabric pleat ironing machines which are patented, and now these are very commonly used for pleating. Even for sari pleating, these are most commonly used nowadays. Earlier it was inspired by all the hair straighteners, but now specifically for ironing the fabrics, a special machine is designed, and these are patented. uh, then there are biodegradable composites, biodegradable component cosmetic packagings. So a huge market in cosmetic industry is available, but it is creating a huge problem of environmental pollution also. So if you are coming up with something which can package cosmetic, but which cannot, which can be not harmful to environment also, then it's an invention, and of course it can be patented. And this patent is also there with ELC Management LLC. But if you see some other way that you can again uh, you know deal with this problem, then of course you should get it patented. Then you might have been using L'Oreal long wear mascaras. So just have this in mind next time that you apply the mascara, that it's a patented invention. So how does patent work? How do you get a patent? So it's a four-step process. You have to file a patent in a prescribed manner, in a prescribed appropriate patent office. There are four patent offices in India: Delhi, Mumbai, Kolkata, and Chennai. So whichever region you reside in, you can file the patent application. Now it's available online. Publication happens out of that application after 18 months, which you can expedite, which means that you can get it published within 1 or 2 months. Now this publication simply means that they want to show the public that we have received this kind of application, and if anybody has any objection, raise it now. So that is the only meaning of it. It doesn't mean your rights are secured just by publication. What happens next is examination. So they examine your application for, again, many formal examinations, many substantive examinations, whether you follow the patentability rules, whether you come under any non-patentable invention category. So those are examined, and then your patent is either granted or refused. So it's a four-step process. In the next session, whenever we will be having it, we can discuss this process also in detail. But just to have a brief idea about it, it's filing, then publication, then examination, after which your patent is either granted or refused. And once your patent is granted, you have the rights, all the commercial rights related with it, with you, secured and protected, and nobody else but you only can make benefit out of it. So now there is a second intellectual property right. which is called industrial design, which is very, very connected to your industry, the fashion industry. Every product you see right now with you, around you, surrounding you, is a product of industrial design, and most of them are already protected. The bottle, water bottle, if you may be carrying with you right now, is a product of industrial design. And yes, all the bottles, all the packaging bottles that are available these days in the market, be it water packaging, be it your cosmetic packaging, be it food packaging, all are industrial design protected. And that is why you can see the difference between Himalaya bottle and Bisleri bottle, and both are distinctively different, because nobody can copy others design, and everybody has the right to protect their designs. And therefore you can see every company is coming up with new packaging, because all the earlier companies have protected their designs. So you should also take an example out of it, that if you are coming with a new design of something, maybe a handbag, maybe a footwear, maybe a, some utility items, some articles, some industrially usable products, like your ironing or anything, then you should get it protected under Industrial Designs Act. If it is a new design, need not be an invention. Like for example, see, footwears are not an invention. Footwears have been invented decades ago. But whenever anybody comes up with a new design of a footwear, it's a new design that was not used before, and it should be protected under industrial design. Although it cannot be protected by patent because it is not an invention, a new design to any available thing can be protected by industrial designs, and it is the most relevant to your industry. So just wanted to show some examples which Biba has protected already. The fashion house Biba Fashion Limited has protected their drawings, photographs, tracing, and specimens of the designs that they create as surface pattern on the fabrics, on the textile that they use. And although the pictures are not very clear because they have been taken from the Intellect IP website, IP India website, but yes, whenever you create such surface patterns on your textile, embroideries on your textile, any new designs, block prints, what other things that you create. I may not know all the terminologies, but if you are creating any surface patterns for your textile, which you are going to use as a raw material for making dresses, lehengas, or anything, any article, any apparel, then it can be protected by industrial designs. Biba has this done this already. You can see this Asian Paint Limited textiles also. Now, Asian Paints, we knew that they are in the paint market, but slowly and gradually they have entered into wallpapers, and now into textile market also. And they have also protected their wallpaper designs, their textile designs. And these days, you know that Manish Malhotra is also has also entered into this wallpaper and home decor range, and all his designs are also protected by industrial designs. Not only these surface patterns, but the jewelries, rings, necklaces, bracelets, earrings, brooches, every fine jewelry, or even every precious stone related jewelry, precious metal related jewelry, imitation jewelry, costume jewelry, are also protected by industrial designs. So you can see these are the examples which are protected already. So you will see that how the gemstones are fitted in a bangle, that arrangement of gemstones are protected in an industrial design, which you can see as an application number 366315. So these are again a few more examples of precious metal stone arrangement, and they have protected these arrangements so that not anybody else but only they can use. And if anybody else without their permission uses these designs, it stands to be an infringement. So even if you create any design which is already protected by anybody else, even if you don't know, it is an infringement, and people can sue you. And that is why it is very very important to know intellectual property rights. And when you create any new design, I would recommend you go and search on this and IP websites, intellectual property rights website, that are these designs already protected. If so, even if you create one piece, two piece out of it, it can be an infringement, and that person can sue you for infringing their designs. Okay. Then there are articles of clothing which are protected by under the industrial designs. So there are different classes under class 2, 1, 2, 3, 4, 5, 7. Under the different 7 categories of articles of clothing are there, and under these different categories you can protect your uh, wearables. So just to show these examples, this wearable breastfeeding support has been protected by industrial designs. Elastic lungi has been protected by industrial designs. All the designs of Sabyasachi uh, Calcutta LLP have been protected by industrial designs. And let me tell you, if their one product is being sold at a price of 1 lakh, which is a very low price, but still, if just for example, then their designs are sold for tens of lakhs, because it is only one product that they sell of that particular design. But when they sell the design, the people who purchase their designs make multiple products out of it, and they make multiple copies of it, and make a huge money out of it. And therefore all these fashion houses protect their designs, they sell their designs, and because they protect their designs only, they are able to sell their designs. And trust me, they make much many times more money than the money they might be making out of just selling their products. So these are again more examples of the products design protected by Sabyasachi. These are again design registrations done by Sabyasachi. Now, this is a design protected by Harpreet Narula for a garment set. You can also protect a set completely. Earlier, you just saw these one article complete, but if you have a set, complete set of lehenga, choli, and dupatta, so that complete set can also be protected. Even in menswear category, you'll see these band galas are protected by Sabyasachi. Uh, there's Goyani Ashish, who is also protecting it. There's Vedant Fashion Limited, and there are so on and so forth. Right. So unlimited industrial designs you will see which are protected by Sabyasachi on websites. Okay, then for the wearables, even the footwears, not only jewelry but even the footwears are protected by industrial designs. You'll see it as this campus activewears that are very hit in in the market these days, are again protected by campus. Sabyasachi Mojris are protected by industrial designs. Even a part of footwear, if you can create for a new thing, as a new thing, like the sole only, which gives comfort to the wearer, or the upper part, the shoe upper, which can be breathable, then also that is protected. And you can see that campus and other industries have protected such kind of designs. But of course, if you can come up with something new, you should also get it protected. Even these simple elements like buckle, laces, belts, and wheels are also protected. So all these examples right now you're seeing on the screen are protected already by industrial designs. Not only those, but the travel goods like handbags, wallets, or your umbrellas, parasols, sunshades, even the cosmetic product containers. So you will see different appealing containers are coming up in the market these days, and they all are industrial design protected. Nobody else can use it except for their manufacturer. if you also come up with such kind of new designs with your for your product, or if you are thinking of entering into this industry of cosmetic production, think about creating some new design containers, get it protected before entering into market. And even the makeup kits that are available in market these days all are industrial design protected. And if you are thinking of also creating something like that, it should be protected in the by the industrial designs. Now, why it is important to protect design is because when companies are competing at the equal price and functionality, then of course only and only the design is the factor that really makes the difference. So, even if you imagine that you are buying two, that you are having option of buying two products which are having same price, which are of the same quality, then definitely you will pick up the one which is of a better design, right? And if that design makes that much difference, it gives you edge over the competitive available products in the market, then of course that design should be protected. And that is why it is very important to protect design. And it is very important for the fashion industry people like you to understand and learn about industrial design acts. This is an example of a jacket we have already protected for our client. Then there's this third intellectual property right, which is copyright. You might have heard this word many times. What copyright protects is a creative expression of your thoughts. Okay, now you can express your thought in the form of literary work. So you can write down your thoughts in your diary. Maybe you can create a poetry out of it, an article out of it, a novel out of it. So such kind of creative expression, when you bring it into the literary form, into the form of words, that is protected under literary works category of copyright. If you create artistic work out of it, like you make those sketches of the apparels that you want to stitch, right? Those are the artistic works that you create. So that gets copyright protected under artistic work category of copyright. Now here you will see there is a little bit overlap, that those sketches can be protected under copyright also, and those sketches can be protected under your industrial design acts also. So what is the difference is, both give you equal rights. Both are correct options for protecting your work. It just depends on, do you want to keep it to a limited edition, not more than 30 40 copies, then copyright is the right option for it. But if you want to make a large scale production out of it, more than 50 copies, then it needs to be protected by industrial designs, because in that case your copyright ceases to exist. I mean, it stops to protect your design. So if you are thinking of making a limited edition, not making more than 30 40 copies of that specific design, you can just protect it with copyright. If you are thinking of making more product out of it, more copies out of it, more than 50, then you should go for industrial design protection. Then the dramatic works, like the performances, the stage performances, are protected under copyrights under dramatic works category. Sound recordings, the jingles, the tunes that we use, the songs that people sing, the lyricists that are being sung, they are all protected under copyrights. Musical works, the tunes are protected under copyright. Cinematographic films are protected under copyright. So if you are also making even the reels that you create these days, or the advertisement videos that you create these days, are all protected under cinematographic films protection under copyright. Even the softwares that are created, the codes that are created, are protected under Copyright Act. So although it may seem like non-creative work, it may seem like a very technical work, but yes, it is a product of copyright, and it is protected under copyright. So if you are thinking of creating a new maybe app, an application, by using the software code that you have created, then it can be protected under your Copyright Act, and it can give a protection for your software. So to be protectable by a copyright, what does it has to have is a simple creativity minimum modicum, which means it should be basically simply creative. It should not just be a scribble on a paper. It should satisfy a minimum modicum of creativity. It should be original, not copied from anybody else, but your own creation, and it should be in a fixation format. That it should be brought in a some specific format, not just in a, in your brain, in the form of any idea. It should have come on fixation on a paper or on a file. In the case of tune, maybe it should have been recorded tune. So some fixation should be given to it, and then if it satisfies all these criteria, it is copyright protected. So how long do these protections give you protection? So patents are protected for 20 years. So once you get a patent, for 20 years, nobody else but only you can use your patent. If anybody wants to use your patent, your invention, they have to take your permission. You can give permission free of cost, up to you for sure. But of course you take patents to make commercial benefits, right? So whenever in between the period of 20 years somebody wants to take use of your inventions, you want to use your patents, you can license them, sell them. So they are active for 20 years. So 20 years is the duration you get to protect your invention. Designs are protected. Industrial designs are protected for 15 years. Copyrights are protected for 60 years. In some cases, like in artistic copyright or literary copyright, it is protected for the age of the creator plus 60 years. So, your age, whatever your age would be, for your lifelong it would be protected, and even after that it would be protected for next 60 years. So that is a huge duration you get to protect your copyright. But the most important thing is all these IPs are country specific, region specific, so they are called as territorial rights. So if you take a patent in India and you feel like nobody else in America would be able to use it without your permission, that's not true. You have to take every country patent separately to have a protection in that country. So it is very much important to understand where your customer base lies. If your customer base lies in India, it would be of no use to have a US patent, and vice versa again is the case. And then you should take a decision as to which country you should get your patent or your design protected in. And after this duration is ended, like the 20 years of patent or 15 years of design has ended, then your invention, your creative product comes into public domain. Then anybody can freely use it. But that's a huge duration already, and after that duration anyway the technology becomes obsolete or the design becomes obsolete. So it already gives you a huge commercial benefit for a long duration of 15 to 20 years, and in case of copyright it's actually up to your life plus 60 years. So this is how the intellectual property rights are. So there's again this intellectual property right which we call as trademarks, which protects names, logos, jingles, taglines, color combinations, anything that gives uh, goodwill to any company, any product, any business, any service into the market in their client's mind, then that is protected under trademarks. So you will see in your industry these registered trademarks, these famous registered trademarks of Masaba, Sabyasachi, Manish Malhotra, and Biba. These all are protected under trademarks. Their color combinations are protected, their fonts are protected, their arrangements are protected. So these are registered trademarks. So all these intellectual property rights are interrelated also, and they're independent also. How they're interrelated is, you can think of any one product, for example the shoes, and it is protected by multiple intellectual property rights. So you will see that it's boost technology, which is an invention, is protected by patent, whereas the material that they have used can be protected by a trade secret. Now, trade secret is again an intellectual property rights where you don't need to disclose anything and you just can keep it a secret from the market. Trade secret can be anything. It can be invention, it can be client list, it can be supplier list, it can be a specific ingredient that you use. For example, the Coca-Cola formula is trade secret protected. So any specific composition of making anything can also be trade secret protected. So you will see that one product can be protected under multiple intellectual property rights, and there are multiple products in the market these days. So if you just imagine your mobile phone, the technology within that mobile phone is protected by patents. The look of the mobile phone, the complete arrangement of that mobile phone, physical arrangement, is protected by industrial designs. The logos that you see on your mobile phones are protected by trademarks. Uh, the visual data that you see, the UI UX, they are protected by industrial designs, and the information brochure here, or in the information that you see in the literary formats, are protected by copyrights. And same is there in case of your fashion products also, that one product is protected in multiple ways, and that is how industries survive. That is how the big brands survive in the market, because what you need to stand out in the market is to prohibit your competitors from copying what you have created new, right? And IP is the only tool that you can use for having that protection from prohibiting others from copying your invention, because if it's a protected technology by a patent or trade secret or copyright or design, then nobody can use it. And if anybody uses it, you can't sue those person, you can ask those person to pay you royalty, you can ask those person to stop manufacturing it, you can even imprison them, right? So IP is the only tool for that. And yes, that's it from me for today. We'll learn in detail about more of the IPs in future. I'm sure you have planned for it already. But for today, if you have any questions, I'm open to answer. Thank you.
Thank you so much, ma'am. It was a very enlightening session. Probably I can open it now for questions.
Yes, please.
Ma'am, thank you so much. It was very important for all the students and everyone of us to hear from you.
Thank you.
Thank you
Thank you
so
so
much.
much.
Girls, if you
Thank
have any questions, kindly ask. I think that's about it. Smita, ma'am, you can just conclude the session. If anyone has any queries, they can write to us and we can forward it to Khushboo, madam.
Sure, sure, sir.
So then, on behalf of School of Fashion Technology, ma'am, I would like to thank you for your time and for enlightening us on a very important
Thank
thing with respect to entrepreneurs and innovative ideas. Thank you so much, ma'am.
My pleasure, ma'am.
Have a
It's
nice day,
indeed a
everybody.
pleasure. If anybody has questions anytime later, also they can connect with me on my LinkedIn or my personal mobile.
Absolutely, ma'am.
Thank you
Thank you
so
so
much.
much. Thank you, ma'am.
Thank you.